With me today on this webinar is my partner, Kevin Battle, and my partner, Mike Strasser. The three of us are part of the immigration practice group here at Miller Johnson. We are certainly supported by some great staff. It's not all the work is not done by the three of us by any means. We have two additional lawyers that work with us, Mike Griswold and Dan Perk, and two excellent paralegals, Stephanie Robinson, Hillary Witcherly, and support staff in addition that help us keep the immigration matters moving along. Our goal today is to provide you practical advice that you can use in your recruiting and talent acquisition challenges. We're hearing from a lot of our clients that it's a tough market out there for employers. And as we call it, the immigration tool certainly can be useful in meeting some of those challenges. So with that disclaimer out of the way there, today's topics are going to cover the benefits of using legal immigration options to fill your employment vacancies. We'll talk actually in some detail on how to determine the best option for a candidate, and try to give you some additional insight on the temporary or non-immigrant visa classifications, as well as the U.S. permanent residence or the green card process, on how that can work to meet longer term employment needs as well. So one question we hear often is pursuing employment-based immigration even worth it? There's some accurate and some inaccurate information out there on cost and timing. So that's certainly a valid question. What are the costs? And we'll come into that. How much timing? Is it even feasible or practical for a professional job or non-professional job? So those are all good questions. So I'm going to let my partners answer those questions.
So I'll start. Absolutely, yes, it is worth it. So, you know, foreign nationals remain a large source of highly skilled talent that is available in the United States. Sort of the last statistics were roughly 17% of our total civilian workforce is made up of immigrants. Over the years, there have been several visas that have been developed for recruiting and sourcing talent. So there's plenty of options available for those who have sort of a formal advanced education or training to accomplish your goals. And we believe that utilizing sort of legal immigration is a great, powerful tool to help diversify your workforce and fill those hard to fill vacancies that we're hearing from our clients. And then also sort of the last thing I'll say is that it also provides sort of that unique opportunity to provide perspective about your organizations from someone who may be from another country. They may work for one of your subsidiaries or affiliates, may have already some information about the organization, or they may not, and they'll bring that sort of unique perspective to your operations.
Right. And, you know, it's worth it to do it now, and it's going to continue to be worth it into the future. The employment market, you probably don't need me to tell you this, continues to evolve. We're aware of three key factors that are going to change as over the next decade or so, including fewer US-born workers of working age. That population will continue to shrink. A separate factor is automation will continue to displace workers, which can be helpful, but of course we need the folks who can manage that technology and manage that automation, and those are highly skilled workers, which we'll get into this afternoon on why immigration options are uniquely suited to fill those types of roles. And also the change that you've all seen and we've actually seen here at Miller Johnson includes alternative staffing arrangements, contract workers, remote workers, maybe around the world, certainly out of town and out of the office as well. And so as things continue to evolve, immigration continues to be a tool for employers to be able to fill those roles. Immigrants, by the way, are going to continue to drive future growth in the United States beyond the next decade. And so what we see is that the United States continues to attract foreign nationals, many of them students in high schools and in universities, and those foreign nationals want to stay here. And they're a great resource for you as you cast your recruiting net as wide as you possibly can to include those foreign students. Because yes, there is some administrative burden to get them authorized to stay here and authorized to work here. But to be perfectly honest, we think the burdens are modest, but the advantages, including the competitive advantages of casting your net wide enough to include those folks, outweigh those burdens by a long shot. In our opinion, frankly, it's not even really close. So we'll get into now, I think, the details on how to do some of those things.
Yeah, and maybe just to underscore Mike's point, I don't want to spend too much time on statistics, but on average, the United States has over 1 million international students studying in our university and colleges. And a quick internet search, will just also underscore perhaps the importance of understanding the immigration options. Engineering field, 21% of the students in the engineering programs in the U.S. are foreign nationals. Similar number with math and computer science. Only slightly less, 16% of the students in a business and management program are foreign nationals or international students. So, you're at 1/5 of the potential candidates right there are foreign nationals, international students that could be joining your workforce if we can help you gain a handle on the immigration options. So what are those options? When you're on campus recruiting, or you may see a resume or CV come across your desk and see reference to some of these non-immigrant visa classifications, non-immigrant, again, referring to a temporary type visa, although as you'll see, those temporary visas can still grant a legal stay and work authorization for several years. So just a quick overview. The B1 class is the business visitor visa class, often issued B1/B2, depending on the type, the main purpose of the trip. B2 is tourism or pleasure. You may see, and we'll talk a bit about the E class. These are just paragraphs of the Immigration and Nationality Act. So if you're reading the statutes, keep reading down the pages, you would come to this E1 class for treaty traders. We'll spend some time talking about that. That can be a good option. There's subparagraph E2 for treaty-based investors. There's an E3. It's rather unique. It's for Australian nationals only. So rather limited, but useful if you have a candidate from Australia. One of the most popular, very popular, you could say maybe too popular visa classification is the H1B for specialized knowledge occupation workers. We're going to dig into that a bit more because that is a good option, a popular option. We're seeing more demand in, you could say, non-traditional uses for the H2B, which is temporary, seasonal, or peak load workers. One paragraph above that is the H2A, which happens to align nicely with the agricultural industry. We'll talk a little bit about the H2 program. H3s are for trainees, and we've seen increased use for those because of some caps or quota issues, and it's another way of at least getting some skilled labor in the United States and using on-the-job training as a component of that. There's a J1 class, which is a broad class of visas. We'll spend some time talking about the J1. L1s are for intercompany transfers, a very effective option for our multinational companies that can share mid-level management, technical or skilled workers, even in the executive ranks as well. I think Mike's going to talk about extraordinary ability. That is for the kind of the elite of any particular occupation. But it is when you have that truly unique, quote, extraordinary individual, that is a good option as well. Religious workers can also be used for religious organizations, not just for the clerical role or priest or minister. We've used those for religious organizations in some broader categories, including teachers, publicists, and the like. And TN, the TN for Treaty NAFTA is still around. We haven't renamed it yet for immigration purposes. So the US, Mexico, Canada Free Trade Agreement, especially here for Michigan, we got Canada just to our north. And a lot of flights going down to Mexico, bringing up skilled Mexican nationals for job opportunities as well. So that's kind of the proverbial alphabet soup of what you may see for the temporary or the non-immigrant options. I'm going to let Kevin jump in on some more details here.
Sure. So when we're determining, what type of visa might be applicable to a particular situation, we generally work with clients to figure out, what is the purpose for which you want to bring the foreign national to the United States? What is the job? And those are sort of the conversations that you have at the beginning. And so we'll kick it off with sort of the business visitor visa, which is probably usually the quickest option to get someone to the United States for a business trip. And so the purpose of the B1 business visitor visa, as John sort of talked about a little bit earlier, is to have someone come to the United States for a visit for business purposes. These what we like to refer to as permissible business activities. So this visa itself is not going to grant someone U.S. employment authorization. It doesn't provide for employment authorization, but what it does allow is it allows you to bring someone from another country to the United States to engage in certain permissible business activities, such as consulting with business associates. It might be negotiating contracts, attending conferences, short-term training opportunities where you want to bring someone to your organization. That is what you would use sort of this B1 class for. It can be used for sort of international exchanges and transferring of information to different individuals and different entities that you might have. It's generally thought of as sort of a short-term visit, something that does not exceed 6 months to a year in some cases. And this visa, when you initially get a B1 visa, it can be granted for up to 10 years with multiple entries into the United States. So when you have someone who goes to the consulate to get their visa, they'll generally give them a B1 visa for 10 years, so they don't have to keep coming back to the consulate and getting another one. And with that, they are allowed multiple entries into the United States of usually up to 6 months at a time. It's something that can be secured quickly with an interview to a U.S. consulate abroad. Usually, the cost is minimal. A letter from the employer inviting someone to the United States, and then generally the cost of the actual B1 visa are the only cost that you generally incur. And the next classification is sort of the E1, E2 treaty trader, treaty investor visa. So the United States has a list of qualifying treaties on the Department of State website, which lists the various countries that either have E1 or E2 treaties. And this is used for those who are investing in a U.S. company. Either it's going to be a current investment or an investment that already occurred, where we can bring over individuals who are in an executive, a managerial, or a capacity where they might have some sort of specialized knowledge. And if those individuals are foreign nationals of the company, of the treaty country that controls 50% of the business, then those individuals are going to be eligible to secure either E1 or E2 treaty investor visa. They're generally granted in initial 2-year increments, but there's no limit on extensions. So if you're able to secure an E1 or an E2 visa, you can continue to renew that indefinitely. And then another thing that is a perk of sort of this E1 or E2 visa is that the law permits for employment authorization for the spouse. So a lot of times, and sometimes you'll hear today, you may have a visa where, yes, you can bring your dependents, but that may not authorize work authorization for those dependents. The E1 and the E2 visas do allow for work authorization for dependents.
Hey, Mike, before we jump into the H1B, I want to honor our promise to address questions that are relevant throughout the topic. So we did get a question about training and hands-on training. The example with the question was, for example, a mechanic coming over from Canada to the US to be trained on equipment. Is that training permitted? So the short answer is, I would say yes. The qualifier is because the B class does not authorize employment, that US entry would need to be managed and demonstrated that the mechanic in question or any worker in question, that they're still, employed outside the United States, whether it's Canada or coming from any other country, that it is a training opportunity, not a job opportunity. So it can get complicated with on-the-job training. I guess that's good for us lawyers. It gives us an opportunity to, one, help prepare the individual so they know what questions to expect at the border or the airport. We call them pocket letters at times, where we draft a letter that's to you as HR or to you as a supervisor, but the intended audience really is the folks at the border or the airport, so they can understand that the activities, fall within this B class. But yes, training is the operable word there. If it looks, smells like a job opportunity in the United States, then we need to find another visa class.
Continue to take us through the H's. So the most popular probably, and the thing that you probably all heard of is H1B visa. It is a visa option for what we call specialty occupations. And that really is those jobs that we deem as professional, meaning that the candidate holds a bachelor's degree or the equivalent of a bachelor's degree, and that the position itself requires at minimum a bachelor's degree. And then sort of with the caveat, when we talk about bachelor's degree or equivalent, we can get a degree evaluated if it's a foreign degree, to make sure that that degree evaluates to a U.S. bachelor's degree. There's also this rule out there for H1Bs where we can make up some educational academic study with experience. So for every 3 years of sort of work experience or specialized training that someone might have had, they deem that to be equivalent to 1 year of sort of a formal education. So in evaluating whether or not you have a position that an H1B would be fit for, the USCIS often looks sort of at their own government internal resources. So that's usually going to be the Department of Labor's Occupational Outlook Handbook, or OOH, or the ONET system online. We've sort of linked those websites in our PowerPoint. But if you're looking, or if you have questions about whether or not a job would qualify, I would start there and say, what do I feel like this job is closest to based on, our title, the job duties. Start with these government resources, and they will tell you what the government thinks is sort of the baseline minimum educational qualifications for the job. The H1B visa has a couple of requirements, and one is you have to get an LCA, a labor condition application, and that labor condition application is essentially a contract. It requires the employer to pay the prevailing wage, which is going to be the higher of the wage rate paid to others with similar qualifications, performing similar duties, or the rate for the job in the geographic area. So that's one thing. You'll have to file this LCA document with the Department of Labor, which will indicate the time period for the H1B and also the wage that you're agreeing to pay the individual for the job. And then another requirement associated with the H1B is if the employment ends for some reason, whether that is you ending the employment or someone else, there's this return home requirement. And the return home requirement is the offer to someone who's on H1B to return them to their last country of residence. You don't have to guarantee that you have to do it, but you have to make the offer to them that we will provide you with reasonable transportation back to your country of last residence. The H1B program, we are going to get an initial, generally a 3-year grant with extensions of stay that would total 6 years. So usually you do an initial 3-year H1B, and then you are allowed to extend that for an additional 3 years. There are certain circumstances where you can get an H1B beyond 6 years, but that requires sort of you to have gotten through that permanent residence process that we'll discuss sort of at the end.
Hey, Kevin, let me ask what should be a softball question for you. The prevailing wage, how long does that take us or one of our skilled paralegals to provide an employer, just so they can gain some insight? Is their wage rate good enough? Is this going to require a higher level of wage? What can you add about this prevailing wage issue?
Sure. So, for H1B purposes, determining whether or not your wages would be at or above the prevailing wage would probably take us something like 5 minutes to make sure. There are resources we need to talk to you about. Okay, what is the job itself? What area, what location is the job in? And then from there, we could determine with pretty reasonable certainty of what we think the prevailing wage would be. And we could let you know.
Yeah, and maybe just to underscore Kevin's comment there, it is local prevailing wage data. So if we have an engineer that we want to employ in Grand Rapids, we're not going to be required to meet a prevailing wage for Silicon Valley or even Chicago or New York that would likely see a higher wage rate. Before we move on to some more H1B details that are all the more relevant this next few weeks, there was a good training question that I wanted to address, and that question is, what about someone providing training to our staff in the U.S.? What options exist there?
I think providing training would be, you could use that B1 visa to provide training. Again, it's not going to be a situation where there's a job opportunity where someone is going to be on your payroll. You're going to pay, if you're paying them to have that training, it's not a salary remuneration for services. And so that would be a good option for someone to come in to provide some sort of training.
And then one more e-visa question that I failed to address, failed to ask. The question is about an ESOP, employee stock ownership program. Would that meet the investment? The short answer is it might, but a critical issue with the E-class is the investment must come from outside the United States. So the way it works, the investment or the trade has to be between the U.S. and another country, or the investment must come either from an individual or from an outside corporation, a corporation headquartered or based outside the United States. And the other issue with the E-class that may bear emphasizing is it's treaty-based and you do need common nationality. So if you're a German-based company, you want to target German nationals because that's the only group you can sponsor for that treaty-based E-class visa. If you're a Japanese, auto supplier, and you're headquartered abroad, then you want to target Japanese nationals. You couldn't hire a German engineer under the E-class. You could probably hire the German engineer under another class, but we need common nationality. That's another key requirement of that E-class. All right, we digress. The H1B, as we call it in the immigration group, it's H1B season, or H1B season's about to start. What are we talking about there, Kevin?
So we have this fun thing called the H1B cap that happens every single year, sort of in March. So there are 65,000 H1B visas issued each fiscal year for those who have a bachelor's degree or higher. That registration, here's a shameless plug, registration opens on March 1st at noon. And then continues until March 17th at noon. And then so we have 65,000 H1B visas up for those with bachelor's degrees, and then they reserve another 20,000 of those H1B visas to those who have master's degrees or higher from a U.S. institution. The cap itself applies only to those individuals who have a new H1B. And so to the extent that you have someone who is already subject to the cap and they won the H1B lottery, then they're not subject to the cap again if they transfer to your organization. With the lottery system, so I'll talk a little bit about the lottery. We register people in March. It requires basic information about the company itself and the foreign national that you would be registering. There's a fee of $10 to enter someone into the registration. And then once the registration closes, they will randomly select 65,000 of those for the regular cap, and then the additional 20,000 for the master's cap. And they usually select a few more people just because some of those people aren't going to work out. But for a point of reference, last year they received almost 500,000 registrations for those 85,000 total slots. So the chances, the percentage usually works out to be somewhere between 20 to 25% of people who enter the lottery are selected. And then ultimately, if you are selected or you do have an individual who's selected for the H1B lottery, the next step in the process is that they notify you, and then you have generally 90 days to file an H1B petition, which is government forms and information that establishes that the foreign national has the requirements of the H1B and that the job meets the requirements of the H1B program. So you file that within 90 days of being selected, and your H1B itself becomes effective October 1, 2023, which is the start of the USCIS's fiscal year each year.
For those of you who may have tried this H1B lottery in the past, it is unfortunately still a lottery. But one important change that happened, if my memory is right, just this will be our third year with this current registration process. The good news for all of our audience members is, as Kevin mentioned, it's a $10 registration fee to the government. You can do it on your own, or you can hire us to do it. We do charge, typically less than $1,000, which includes an evaluation of the prevailing wage, confirmation that the job and the candidate will actually meet the H1B criteria. So depending on how much work we're doing for you on the registration, we'll dictate those fees. But it is far, far less than what we had to do in the past. In the past, we had to do a full-blown H-1B petition, pay government filing fees, put a petition together, all the underlying supporting documentation, file it within the limited window period to file, and then cross our fingers that we were selected. If we're not selected, the government would refund their filing fees, but as lawyers having done that work, we would not refund our fees. So far better that it's a nominal upfront cost for the registration, but still, to me, a very bad policy to allocate a highly needed visa category for skilled workers, especially in this current job market. So the other main takeaway there is pursue existing H-1B workers, because as Kevin noted, the cap only applies to that initial H-1B issuance. So if you find an engineer, you find an IT professional who's already has an H-1B, we can certainly help you get a change of approved employer, no cap, no lottery. So that's an important takeaway. We actually have clients that's a major part of their strategy, that they target candidates that already have the H-1B visa to avoid this registration process. Well, I mentioned some cost. Kevin, you want to give us some more ideas on costs and filing fees and the like?
Sure. So H-1B filing fees and costs, generally, for a total, you're probably looking at somewhere around $6,000 to $7,500 for the full 3-year visa. And so you see sort of that breakdown. There's a USCIS petition fee of $460. They have this American Competitiveness and Workforce Improvement Act, or what we refer to it as the ACWIA fee, of either $750 or $1,500, and that is dependent on the number of employees that you have. So if it's over 25, you'll be paying the $1,500, and if it is under 25, it's $750. There's a fraud protection fee and detection fee of $500, and then on average, you would probably expect around $4,000 to $5,000 in sort of legal fees for the process.
Maybe just a point of clarification. On the ACWIA fee, the $750 versus $1,500, that's the employer's total workforce, how large that employer is. It's not the number of H-1B workers. So correct. The government considers employers with 25 or more a large employer. Those larger employers have that higher fee.
Yeah. The other thing with fees too, the regulations don't allow for the foreign national to pay any of the H-1B fees. So we just like to tell people up front that that's really an employer cost. So it's an investment from the employer, and it's not permitted to, make some sort of deal with the foreign national to pay for the H-1B.
Good point. Good question came in. Does the candidate have to already be identified for this H-1B visa registration, or can you register for a job?
So you do have to identify the candidate with the registration. So with the registration, you're going to have to provide information about the foreign national. So their name, their birth date, their passport information, what country they're from. So all of that needs to be completed at the time of the registration.
And maybe one more point of elaboration before we change gears here. Looks like the audience is paying attention. So for that H-1B worker that we found, someone already has an H-1B working with another company. What do we have to do to get them on our payroll and working for us?
So pick up the phone and call Miller Johnson. No, what you would need to do is you would file what we call an H-1B change of employer petition. So It would require a lot of the same steps as an initial H1B, not the registration part, but once we got to the filing of the petition, we would file USCIS forms, information about the employer, information about the foreign national, and request that they change the employer of their current H1B visa to your organization. It still requires, filing the petition fee, the QIA fee, the fraud detection fee. You do pretty much every single thing you do with the original, except for you don't have to go through that registration process or the visa or the H1B Visa Lottery.
Because I know from our audience, we have people that are probably entirely new to this whole immigration process, and I recognize some names that we've worked with in the past, but it does perhaps bear repeating that all of these visas we've talked about, with the exception of the B class, the E visa, the H1B visa, those are, quote, employer specific. So just to underscore what Kevin had indicated, if you have a job candidate with an existing H1B visa, that's employer specific to that last or current employer that filed a petition for that individual. So a new petition would have to be filed. Not to get too much in the weeds, but there's some good news there. Not only is there no lottery, but regulations were passed years ago that we can immediately put that H1B worker on our payroll while we're waiting for the government to process, as long as we have a good faith basis that our job is also H1B worthy. So some advantages certainly there. All right, Mike has been patiently waiting to talk about intercompany transfers.
Yeah, but H's are important, and there's a reason why we spend so much time on them, because they're such a powerful tool for us. I'll just tell you, so we don't get too caught up in the details. If you find a candidate who's already in the United States on an H-1B visa, you should seriously consider moving forward with that candidate if they otherwise are qualified and seem like a good candidate for the job. We can make that transfer application work in the huge majority of cases. So I would encourage you to go ahead and give those folks serious consideration, because you don't have to worry about the cap and all those other things. So, okay.
Hey, Mike, one more question just to underscore this point. Good question, just for clarity. Are the filing fees, the legal fees going to be similar if we have this H1B candidate?
Yeah, so they're going to be very similar because the application is virtually identical. We ask for a transfer rather than an initial visa. So the fee, the work that goes into it, certainly the fees to the government are exactly the same. And all in all, the cost is going to be virtually the same.
Yeah. Before we let you jump into the L1, there's a good question here that popped up too about this prevailing wage, actual wage. Yeah. The question is, if we have a number of employees performing similar duties or a wage rate, you want to give a little more insight on how that prevailing wage works, one of you guys?
Sure. So I'll do that. It takes a bit of an analysis, and it's critically important to get this right. There are when we make H visa applications, we are making a number of representations to the Department of Labor in terms of what we're going to pay the individual, what we pay other individuals in the same job, and there are protections in place that prevent an employer from hiring skilled foreign labor and pushing wages down, right? We're going to have to pay our foreign nationals at least the amount that we pay others in the same job and the prevailing wage, whichever is higher, right? And so I saw the question is, well, there could be differences, there could be a pay range. Those are all things that we would have to analyze to make sure we were paying the appropriate wage for the job. So the Department of Labor publishes prevailing wages, and that is certainly a guide for us, but that sets the floor. And we're in a situation where if we pay higher than the prevailing wage for any particular job, we're going to have to make sure we pay our foreign nationals at least what we are paying similarly situated U.S. workers. Again, all protections against driving down wages, U.S. wages through importing foreign talent.
Good points. And I guess just to underscore why you're hiring lawyers, that's essentially what you're paying us to do, not just get the petition approved. Not every H1B is audited, but the government does audit that prevailing wage issue. And so we're certainly going to make sure that whatever wage rate is decided upon, that collectively, both the lawyers and the company representatives are in agreement that it's going to meet that prevailing wage obligation. H1Bs are important, but we have some other important subjects to cover. So take it away on the L class.
You bet. L, for any of the attendees here who have international operations, we have a visa classification that is designed specifically to allow U.S. employers that have foreign parents or affiliates to transfer in their managers, executives, and others with specialized knowledge. It's an intra-company transfer. So long as at some point we can show a common ownership between a U.S. operation and a foreign operation, the immigration laws allow employers to transfer in on a relatively straightforward basis foreign nationals who work in managerial capacity, which generally means that they manage people. We'd want to show that they have people that report up to them, or executives who are responsible for entire functions of an organization, financial or operations or chief executives, things like that. Certain people who operate at a very high level, or those with specialized knowledge, meaning if you have a company that has some close to unique process or some other type of information, and we have some individual who works for a foreign affiliate who is uniquely skilled or qualified for some role that you need in the United States, we can use an L visa to get that person into the United States. Ls are great. They can be valid for up to 7 years for some people. So while they're temporary, 7 years is obviously a long time. And they happen to be a great step towards becoming a permanent resident in the United States, which is what a lot of foreign nationals like to at least have the option to do if they're going to uproot their families and transfer for years at a time. They'd like to be able to stay oftentimes longer than the limits. And the L visa, if you can qualify for an L1A visa, generally you're going to be able to qualify for permanent residence and to be able to stay in the United States indefinitely into the future. So again, for those who have foreign operations with common ownership, the law allows us pretty easy access without any limits in terms of number of people to transfer those folks.
A good question came up from a staffing company, but obviously the customers of the staffing company could benefit from this insight as well. How about the L1A or L1B for a staffing company where the company has a Canadian operation, another foreign based operation, and they're going to be working on site in the U.S. L is a good option?
It can be, but one of the requirements for the L visa is that an individual works for the foreign affiliate for at least a year prior to transferring to the United States. So there's a real barrier to entry here. So we can't just go out and find anybody. Rather, we're able to use the L to transfer people that we already have, that have already established a relationship with our foreign affiliate. If I'm understanding the question correctly, if we can meet that threshold, then yeah, using an L can work. But again, there's two pieces, well, there's three pieces to it, right? The qualified company relationship, that the person worked in a managerial, executive, or specialized knowledge role for the foreign affiliate, and they're coming to the United States to work in a similar managerial, executive, or specialized knowledge role. So we have to get all of those qualifications together in order to make L work. But again, very powerful tool, and to the extent you have internal clients for recruiting and talent acquisition and moving people internationally, the L is going to be the first thing that we analyze, because we want to get an L anytime where we have somebody who's eligible.
One example came to mind with a client that's very effectively used the L because they have international operations. So they've, leveraged these international students, and instead of going H1B registration, H1B lottery, they'll place them at the affiliate in London or Czech Republic abroad for 1 year, and
Right.
then bring them back to the United States. So that's just one example how, we can help you come up with some, you could say, creative solutions, avoiding a lottery, filling the need at the affiliate abroad, and then, having that game plan that our, new IT hire or new engineer is going to be coming back to the United States using an L class. So what if we get somebody who's really, top of their profession?
So there are two sides to the immigration rules in the United States. There's the family-based side, and then there's the employment-based side. We deal with the employment-based side. On the family-based side, the easiest way to come to the United States and to become a permanent resident is to marry a U.S. Citizen. On the employment-based side, the easiest way to come to the United States to work is to be somebody who is at the pinnacle of their field. If you find somebody who is a fully formed professional who has excelled in his or her field, whatever that field may be, the O visa is something we're going to want to analyze for a couple of reasons. Our employment side immigration rules favor advanced formal education, and those with the most advanced formal education, your PhDs and otherwise, can qualify for O visas. Again, there's no limit on them. They can work in virtually any field that's available. We have significant hurdles to get over in order to be able to prove that somebody is at the top of their field. The USCIS won't just take our word for it. We have to demonstrate it through evidence, meaning things written about the person, awards received, other objectively verifiable pieces of evidence that show that the person is near the top of their field. When we can do that, getting an O visa is one of the best options. And it again leads directly into permanent residence, which is great. The other visa, the TN, is something that I think remains underutilized and is an exceedingly effective tool for employers, particularly those in Michigan, because TNs are available only to citizens of Canada and Mexico, and essentially they're available to jobs that qualify for H1B visas. So the huge difference here is that there is no limitation on the number of TN visas that are issued each year, and they can be renewed indefinitely into the future in 3-year increments. And so if, just for example, if we submitted somebody in the H1B lottery who happened to be a Mexican or Canadian citizen and they weren't selected, our next option would be a TN visa, which if the person had the qualifications, let's just say it's an engineer of some type, and we want to employ them in an engineering role, then the TN visa is going to be available to us at all times. And it's relatively straightforward, certainly for our friends from Canada, because they don't even need a visa. They can simply bring the information to the border and apply right as they cross into the United States. Our friends from Mexico need to actually get the visa placed in their passport before they're allowed to enter in TN status, but that's really not that big of a hurdle to get over when we have a job that qualifies and an individual that qualifies. So for any of your real technical roles, any of your engineering types or technicians or things like that, if we were talking it over with you, we'd be thinking about TN visas anytime we see Canadian or Mexican citizenship.
So what's this no intent to immigrate? Can you comment on that?
So what you're going to find as you spend more time dealing with foreign nationals when you're recruiting, there'll be varying levels of understanding in terms of how the U.S. system works. Some of them know it very, very well, and they'll understand that normal process is for somebody to come to the United States temporarily, maybe as a student in F visa status, then get a job and maybe move to H1B visa status, and then want to stay here long-term and move to permanent resident status. And they can do that, and thousands of people do that every year. And it's frankly what John and Kevin and I spend most of our days doing. Some visa categories, though, when we allow non-immigrants to enter into the United States, there is an expectation that that person intends to return home. Kevin talked about the B visas earlier. TN visas are the same. Technically, the law does not allow somebody to come to the United States in TN visa status and intend to stay here long-term. They have to intend to return home at the end of their visa period. Now, of course, people change their minds, circumstances change. And like I said, a TN visa can be valid for indefinitely into the future in 3-year increments. So we can extend it to 3, 6, 9 years. That's all fine. But technically, the person needs to intend to return home to Canada or Mexico at the end, and can't easily transition to lawful permanent residence. Now, we spend a lot of time trying to figure out, when people do change their mind, how to make those things happen and how to help you keep people who have proven to be valuable assets to the organization. And there are things we can do, but this non-immigrant intent is an issue that you will hear us talk about and hear us explain, because it's something we have to navigate.
Yeah, and in the interest of time, I'm going to just maybe interject. There's a good question about timing on the TN. So as Mike mentioned, our Canadian friends, Canadian candidates, I mean, you need some advanced planning just to put proper paperwork together, but I mean, days, a week, if you're kind to us and our staff. So not much time at all with the Canadians. Mexico, they do need to schedule an interview at a U.S. consulate. And literally, depending on the day or the week, you can see those interviews readily available or not so readily available. So, you know, Mexico, the U.S. consulates are still, you could say, suffering from a COVID hangover. Still some challenges there. It may take a month, it may take 2 months to get them into the U.S. consulate. And sometimes we can improve upon that, but you know, a month or 2 may be needed for the Mexico national TN to come across. For the Canadians, we don't have that issue. On timing, we got some good questions here. Certainly want to be respectful of everyone's time. We're planned and prepared to go over our 1 hour presentation. This is recorded, so for those of you who do need to get back to your regular day job, we apologize that we're going to go over, but that recording will be available to you. And we also have I think it's a 4-part blog series that will be on our website that goes into the H1B mechanics process in quite a bit more detail. So if you look for that H1B visa blog, you'll even get additional insights. So yeah, let's keep this moving along though.
Yeah, I'll go a little bit quicker here. J visas are designed for actual exchange visitors into the United States. The theory is that the U.S. created this visa category to allow foreign nationals to come to the United States, learn about how we live and work and operate here, and then take that information home and spread the good word that the United States is the greatest place on the planet. That's why they were specifically designed. We can use them for certain work opportunities, for training or research or teaching. There are a handful of ways that we can get somebody here temporarily, but the thing to take away here is, when I said that the TNs sort of have a technical side that is a difficult path towards permanent residence, J visas have a very large hurdle to get over for somebody who would want to come in J visa status and remain here. Because it was designed for exchange, the theory is everyone is going to have to go home at least for 2 years after they're here in J visa status, before they're allowed to return in some other status. There are limited waivers to that requirement that are available, but you can expect that most will have to return home. Now, it still is on the next slide. Show you that it still can be a very good tool for us to use, particularly for training foreign nationals who might return then to our operations in their home country. We can bring somebody here for 18 months and train them up on our manufacturing processes or some other skill that we need them to have, and then take that home. The J visa category is a very useful tool. Again, we don't worry about quotas or caps or prevailing wages or things like that. There are other requirements, but we don't have to worry about those things. So if you're thinking about trainees or maybe fit into one of the other categories that J's are available for, J's are great. They just have the significant hurdle of requiring somebody to return home.
Yeah, and just to underscore 1.2 is the spouse of a J1, that's a J2, has work authorization based on that status. Same thing, this is worth mentioning with the L class. The L2 spouse gains work authorization with that status. So the point I'm trying to make there is, you as an employer, if you get a job, application from a J2, L2 spouse, you actually don't need us to do any petition filing for you. That individual does have work authorization. Now, you may want to contact us, though, about gaining control so that you have your own control over that work authorization. But the takeaway there is the J2 and the L2 and the E2 spouses all have work authorization incident to that status. So no immediate need to incur legal fees or filing fees to see how they may fit into your organization.
Last non-immigrant visa is the H1B, very different than the H1B. And the H2 exists to allow U.S. employers to fill temporary non-agricultural jobs in roles where U.S. employers can't find workers. The H2A exists to let employers fill temporary agricultural jobs, but for most of the employers out there in the non-agricultural business, there are these 66,000 additional visas that are available if an employer can demonstrate a temporary need, meaning a seasonal need or a peak load or a one-time occurrence that they can demonstrate they have this increased demand and increased need for employees. We can go the H2B route. There are a handful on the next slide, I think, of additional requirements to get through for the H2B visa. Again, these are designed in general to prevent U.S. employers from displacing U.S. workers in favor of foreign national workers. And so we have to go through some steps with the Department of Labor to get a prevailing wage, very similar to the H1B. But then we also uniquely have to show that there are no U.S. workers available for the job, or at least we're taking steps to recruit U.S. workers for the job. And when we find them, we're hiring them, but the supplies doesn't meet the demand that we have. And so we need to look beyond the borders of the United States for workers to fill these types of jobs. It's really useful in industries like construction or landscaping or hospitality, restaurants, amusement, things of that nature. Anybody who can demonstrate through documents, again, they won't just take our word for this, that we have unique peak needs and need those to be met. The H2B, again, in Michigan at least, the H2Bs, you might have read articles or seen things about Mackinac Island and their use of the H2B visas for their peak season during the summer. It's a great example of the type of jobs you might think about when we think about H2B visas.
What about manufacturers, Mike? I think I saw a question from one of the attendees. Can a manufacturer utilize this H2B visa?
Definitely. The hurdle is going to be, of course, well, it's two things really. One, 66,000 sounds like a big number, And I mean, it's a lot, but frankly, if there are a lot of employers fighting for those 66,000, they get used up pretty quick. But the other hurdle is demonstrating that peak or seasonal need, and doing that through documents, showing that we have this period of increased demand that we need help fill.
Changing gears a little bit here, United States permanent residents or green card, they are a shade of green again, so it's proper to call them green cards. So gaining some level of understanding can help with the recruitment process. You may see, for example, existing H1B workers, you had a competitor of yours insisting that they're not going to change employers unless they gain or have a promise that the green card or permanent resident status will be pursued. So understanding what that process looks like can help with that competitive recruitment efforts. By my count, there's essentially 3 steps. Step 1 being labor certification. And this labor certification, we have a lot of acronyms in immigration, and unfortunately we have the same labor certification application acronym as the H1B, but this labor certification is far different than the H1B. With the H1B, there's no necessity at all, no requirement to show you tried to first hire U.S. workers, meaning citizens or permanent residents, to gain that certification. With the green card or permanent resident process, that's exactly the question. Did you first try to hire U.S. workers, meaning permanent residents or citizens? And it's local. It's not a regional search, not a national search. It's a rather, you could say, artificial process. So I know we have professional recruiters, talent acquisition managers at the webinar. The reason you're going to hire an immigration lawyer to guide you through this recruitment process is we have the candidate and we're trying to meet the regulatory process. So it is different, we often say, than, quote, real world recruitment. So that's step 1, and that's the hardest step. We'll get a little more detail on that. But step 2, and only after step 1 is accomplished, do we file an immigrant petition. And this is employer driven. The employer is signing all these forms. The foreign national is the beneficiary and they're named here. And there's different classifications for some nationalities. There can be quota delays. We'll come to that a little bit later. And even if 1 and 2 are successful, they're approved. The green card process, the permanent residence, still involves a quota system that applies or hits some nationalities, India and China particularly harder, just because it's the same number for all countries. And a review of the immigration history, a criminal history check, mental health screening is still in the law. So even though someone's been here, when we're looking at talking about a green card, there are additional legal requirements to meet. We won't spend too much time on this quota or priority dates. If you can't sleep at night and want to read up on that, there's a link to the U.S. Department of State. It's called the Visa Bulletin. That is information we would help track and explain to you with the green card process. But that's a link if you have some curiosity about that. So a little bit more on the process. It can be accomplished 1 of 2 ways. That final step, if someone's here, we have that H1B worker or that L-class worker or that E-class worker, they're already here. We can do the background check through what's called adjustment of status, so they stay in the United States. Way back when the process was shorter, or if we have somebody abroad, we can still go this route, which is consular processing. So the same process, same questions. Are there medical issues? Is there a criminal history? An interview is conducted, and that would apply at the consulate. So some of our Canadian clients, employees will still go to the consulate. Most folks are going to do this adjustment, but same process, just a question of who is doing the final vetting, if you will, or statutory review. Labor certification does have this prevailing wage, different than the H1B, which also has a prevailing wage, but in this context, we have to file an advance application with the Department of Labor. I think the last count is there's literally 8 or 9 people in Atlanta that handle all prevailing wages for the entire US. So they're taking a long time. So we're trying to get ahead of that and file that relatively early. That can take 7 to 8 months. And this process is different. We send in our job information, our locations of employment, the requirements for the job, and the government comes back and tells us what they believe the prevailing wage is. Just to give you some insight into the required recruitment, again, it's some similarities for you recruiters out there. We do place an ad mandatory with the state unemployment office or workforce agency in Michigan. It's the Pure Michigan Talent Connect. There's a list of acceptable recruitment methods, and we'll help guide you through that. Some of it's just a posting at your workplace or on your website. If you're looking at the Sunday newspaper ads and wonder why folks still use that, it's because the regulations say you have to. So a lot of those Sunday ads, sometimes all of those Sunday ads, us lawyers can tell are for this labor certification process. So again, that stuff we'll strategize with you on timing, job requirements. Verbiage can very much matter on how successful we are. Before we transition, I will say this, the good news, silver lining in the current tough labor market is we're batting 1,000. I mean, our labor certifications do take some work, collective work with us and you as the employer. But for the last couple of years, we've been 100% successful. Again, that takes some work and some strategy. But the reality is, if you do what the regulations require, it's rare that we see many U.S. applicants coming forward. So we can gain labor certification the vast majority of the time. So I'll leave it at that for labor certification. That's a whole hour-long topic on itself, but hopefully that gives you some insight on that step one of the green card. Kevin, you want to talk about this preference classification?
Yeah, so the way the visa bulletin that John was mentioning and the way that it's all broken up is by visa preference categories, with sort of first preference being the top. And so first preference is reserved for those individuals with, extraordinary ability, similar to what Mike was mentioning with that O1A, those who have reached the pinnacle of their field. So, when you're evaluating this, the first preference category is generally going to be those who have some sort of major prizes or awards, international acclaim, those who command a high salary, who have material that is published about them, those sorts of people. So you want to make sure that you sort of evaluate the individual, and we can help you with that and make sure that they have that international acclaim. Everybody thinks that they are some, first preference category. I've got exceptional ability, but it's really reserved for those top tier folks. And then along with the first preference category, similar to the L class that Mike mentioned, there is a first preference for those who are international executives and managers. So those who meet similar criteria as the L, who were employed, in a managerial executive position abroad for at least a year, and there's that qualifying relationship between the organizations, they can qualify for first preference as well. No labor certification required for first preference. So John was mentioning that first step with 7 or 8 months for, prevailing wage. We get to skip in the recruitment, we get to skip the labor certification part with those first preference folks. So it can save time and resources if you have someone that qualifies.
So if we have a first preference, we must have a second preference, right? So tell us about that.
That's right. So second preference is generally split up into 2 categories. The first is going to be advanced degree professionals or aliens with exceptional ability. Those are going to be those individuals that have a master's degree or higher, or a bachelor's degree with 5 years of progressive experience. And then the exceptional ability is generally a strong academic record, letters documenting 10 years full-time related experience, evidence of salary and remuneration that sort of shows that they have this advanced ability and significant achievements. And then we have this other category called the national interest waiver, which essentially allows us to, again, waive or not go through that labor certification process. And for the national interest waiver, we need to demonstrate that this individual, that there's some sort of proposed endeavor that is of substantial and national merit to the United States, that this person is well positioned to advance that proposed endeavor, and that it's in the U.S. best interest to waive the labor certification process and let this person just skip that step. We don't have to do the recruiting, and they can go ahead and file their I-140.
Well, what if they're not extraordinary, Mike, and what if they don't have an advanced degree? What's the options there?
There still is a great option. So for any job that requires at least a bachelor's degree as an entry-level requirement, permanent residence is still available so long as we can get through the labor certification, which means there are no ready, willing, and able U.S. workers for the job. So if we can, if we have a job that qualifies, if we have an individual that has the qualifications, and we can go through that recruiting piece and show that we tried, but we can't fill that role, then we can still get permission from the Department of Labor and the Department of Homeland Security to fill that job permanently with a foreign national, again, so long as we successfully complete the recruiting. We can even further down the preference list are skilled workers, which fall into this third preference, but are for jobs that just require as entry-level requirements training or experience beyond high school, at least 2 years. Again, so long as you can show that you can't find folks to fill that job and you've done all the required recruiting steps, then you can pursue permanent residence on their behalf. It's a great tool to use. It does take some time and some planning to get the strategy right, but don't be dismayed because it's simple for those at the top of their field. There's also a process for those who are just entering into the field or who are entering into a field that doesn't require a PhD or some other advanced degree to enter.
So what about that mechanic example? So if I can't find enough mechanics for my operation, skilled worker E3, could I go right to that third preference green card process?
You can. Again, it's the timing is going to be a challenge. And one thing that this is a little advanced, but we have to figure out ways to keep the person inside the United States, working for you while it's going on to make this timing effective. Talk about timing here in just a second. So there are ways to make that happen. It's just going to take us sitting down with you to talk over the fine details of what you're trying to accomplish, when you're trying to accomplish it, and what the person's particular skills are. If we can do all of that, we can find a route for virtually anybody. The thing will all often come down to just whether or not we can do it in a meaningful amount of time. Some of this has to be long-range planning. It's not going to meet short-term needs.
But you mentioned keeping them employed and legally in the United States. What if I have someone working outside the United States for an affiliate and they want to come to the United States and we have a job for them? Do they have to first come to the United States, or can we go with the green card before they even come?
Yeah, we can go straight to the green card. The normal progression for folks is to come on a temporary non-immigrant visa and then move into an immigrant permanent visa. But that's not the only path. We can pursue permanent residence for foreign nationals who are living and working outside of the United States, and have them, their first entry into the United States can be as a lawful permanent resident with their green card essentially in hand. And so there are a lot of different ways to make this happen. A lot of them are complicated, but they can be done. Quickly on the timing, this is generally what we're going to be looking at in terms of timing to get through the process from the beginning to the end. Permanent residence happens in 3 stages. That first stage, about a year and a half, all in as we apply for, we start with the prevailing wage determination and get all the way through to the approval of that labor certification. That's an estimate, but that's a pretty good estimate. Unfortunately, those prevailing wages take way too long, but we have to deal with what we have. Once we get that labor certification, though, the next step, we can get the next piece done if we use the USCIS's premium processing service. We can have that done in a month, which can be great. And then when we get to the third step, when it's somebody's turn to actually apply for adjustment of status, that's going to take about 2 years right now. That's current processing times. They do a decent job of telling us what their processing times are for those things. So right now we're looking at 21 months. And that might seem like a long time. It definitely is a very long time, but there are ways to keep people, particularly those, just for example, on H1B visas, we can keep them here for that entire period of time from beginning to end, no matter how long that takes, even if it takes them beyond the normal 6-year limit of H visa time. The rules allow us, if somebody is sufficiently down the road in their permanent residence and are simply waiting for it to be completed, the rules allow us to keep that person here working and living here while that works itself out. If we had more time, I'd tell you about that in far more detail, but just know that don't let the fact that this permanent resident process can take 4 years dissuade you from pursuing it, because even if we get to the end of the non-immigrant visa, typically we're going to be able to find a way to keep that person here.
We've seen more and more clients successfully go this route, but still a lot of them don't know about it. So engineer, IT person, new hire, fresh out of college with their student visa and work authorization. Do I have to go through the H1B registration? Do I have enough time given this timeline you've just outlined for the green card? Could we go from student visa to green card? How does that work?
Yeah, you absolutely can. And in the right circumstances, that can make the most sense. In a condensed version, any foreign student who comes here in F1 visa status is going to be authorized to work after they complete their degree for some period of time. Everyone, all foreign students who complete a bachelor's degree are eligible to work for 1 year. Some who study engineering, science, mathematics, the STEM majors, those folks are able to stay here and work based on their F visa for even longer than that. And so what John was referring to, and for that work authorization, the upside, the significant upside is that the employer doesn't have to do anything. They will have a document in their hand that authorizes them to live and work in the United States and allows you to complete your I-9 form so you can employ them. But John said, well, and how this comes up is, well, what if we put somebody in for the H visa lottery and they don't get selected? We're kind of out of luck. And that's not really the case. We can actually skip the non-immigrant visa, the H, and go right into the immigrant visa application process. And we might, in certain circumstances, be able to get through that while the person is actually still in their F1 visa, student visa status. And so I guess the takeaway there, it's far too complicated to get through how all of that works in this forum, but the takeaway is when you find good candidates, give us a call. These are things oftentimes we can work through in half an hour, 45 minutes of talking about who we're talking about, what the job is, and what their circumstances are to see if there is a path to keeping them there long term and doing so in the most cost efficient and time efficient way. I just encourage you not to steer away from foreign national applicants or candidates. A lot of your competitors are doing that, and we think that's a big mistake.
There's some good questions that were submitted in advance, so I think we have a few of those queued up. We'll certainly take more questions in the Q&A. We've got, not the whole afternoon blocked up, but we have time to answer additional questions. And here's some that came in with the registration. I'll tackle, I guess, the first three here. Do H-1B employees work at a specific location? Can the employer with different branches, different offices, move employees around? So the H-1B is specific to the employer, and the paperwork requires us to identify the work location. So if with advanced planning, we would identify multiple locations, a little extra work, sometimes a little extra cost if it's in a different government metropolitan statistical area for prevailing wage, but not a Herculean task and not significant additional cost. I'm oversimplifying a bit. Some temporary filling in at a work site or going to a customer site on occasion doesn't require an amended petition. But if we're moving, it is location specific. So sometimes we had to file an amended petition. So planning is the critical point, and that's something we'll certainly help you with so that you have the worker authorized at your desired locations. Does a company applying for an H-1B pay for housing and utilities, et cetera? How does this average wage work for companies? So the prevailing wage, fortunately, is just that, wages or salaries. It does not analyze benefits, which is good or bad. Sometimes they don't get into that. So if you have stronger benefits and your wage is slightly below prevailing, we'll give you the guidance on that, but typically, you have to at least meet the appropriate wage levels. The government gives us 4 wage levels: level 1 for entry level, level 2 for a more advanced person, level 3 and level 4 as you may survive. There is a formula. We won't go into that today. The formula can take into account your job requirements. Do you require more than industry averages? But that's data we share with you in advance, so you know ahead of time and can make decisions. I mean, if it's a large gap and you're like, look, we don't know where the government got that data, we don't consider that to be the average wage for this job, we can't pay that or won't pay that, well, then that's a decision you can certainly make. You can't proceed with the H-1B visa. What do H-1B workers do during the off season? If we're a seasonal construction company, by example. So the H-1B has a starting date and an ending date. It can be full-time or part-time employment, but the prevailing wage law mandates that that employee is physically in the United States. They call it a no benching rule. You can't bench them. Well, you can bench them, but you have to pay them while they're on the bench. So we have to manage that accordingly. We can have it part-time. We can send people out of the country. If there's a gap, hopefully this won't be the case when there's recessions, layoffs. That's issues that we have to coordinate, so you're not running afoul of the H-1B program requirements or prevailing wage requirements. But the government takes a simplistic approach. What's the starting date of the H-1B? What's the ending date of the H-1B? If need be, we can withdraw our H-1B. So if we predicted we wanted a 3-year term and it turns out we don't have need for this worker, or maybe they're not meeting our expectations, we can withdraw that petition. And so we're not stuck with a prevailing wage obligation for 3 years. But until we withdraw that petition or amend it for a shorter period of time or part-time work, we do have to meet what we said as far as hours and wages and time on that petition. So good question.
So how do some people stay longer than 6 years? As we mentioned, throughout the presentation, there are a number of visas that are indefinite. but I think this is probably referring to H1Bs as well. And, you know, to the extent we've engaged in that permanent residence process, then they're not capped at the 6 years if there's not a visa available to them. So you have the options of things like TNs if you have a Canadian citizen or a Mexican citizen, where that can be something that could be indefinite. Those E's that we mentioned are indefinite, but the next progression after a non-immigrant visa is generally that green card process that Mike touched on, and that's how we get people to stay longer than 6 years. The risk associated with H1Bs when you have someone that's placed in a temporary position with a client and that client ends the project they're working on. So John sort of touched on this a little bit, where our H1Bs, they're generally employer specific, and we ask for a certain amount of time. And so to the extent that a project ends earlier, we can either withdraw an H1B, or if there is a new place, a new client, a new project, we can then complete a new H1B for that new end client. So we'd have to move them around. You could sponsor them for a green card, but we'd have to work on timing. As Mike said, it's the process itself takes, you know, probably more than 2.5 years at this point. So some advanced planning, you could definitely sponsor them for a green card. But if you have a project that ends, we could get them to a new project if one's available, or you could withdraw. And let's see, there's a lot in that question. So it's the commitment from the employer. I believe we're asking about the green card here, commitment from the employer, doing that, paying the prevailing wage that you've filed for, advertising, that doing the required advertising, and then sponsoring the employee for the green card. Those are really the only requirements. And is it possible for a manufacturing company to utilize the H2B program? Absolutely, it's possible. I think Mike touched on this a little bit, but you know, you have to make sure that you prove that the need is temporary. So whether or not that is, you know, peak load, you have some sort of contracts that are coming up that you have to deliver something in a particular amount of time. Or there's some sort of seasonal need that occurs, we have to be able to provide documentation to demonstrate to the satisfaction of the Department of Labor that this is a temporary job.
What type of visas can be used in manufacturing? Frankly, they're all available in manufacturing. It's going to depend on the candidate's skills and qualifications, as well as the skills and entry-level requirements that we have for the role. So in manufacturing, it really can be from the executive suites down to the production line. There are visas that are available for all of those roles. They will be a little easier to come by and maybe happen a little faster for those at the higher levels of the company than at the lower levels, at the production level. But that doesn't mean that they're not available. This last question is a really good one. They'd like to know how many visas are available, and it really depends. So just by way of an example of all the visa types we talked about today, 5.8 million people entered the United States in 2021 in B1 visa status, meaning they came here for business. 601,000 H1Bs, 163,000 O1s, 725,000 TNs, nearly 700,000 L1s, 500 and a little more than 500,000 E1s, and importantly for your recruiting purposes, 1.8 million people entered the United States in F1 student visa status in 2021. And so these are huge pools of people and potential employees for you to be thinking about. I think part of the question though is you know, the lottery and how many visas are available each year. And most of these visas don't have a limit. The H1B does. It is 65,000 for those with a bachelor's degree and an additional 20,000 for new applicants each year. The H2B has a 66,000 limit that's split in half. There's 33,000 available in the first half of the year and 33,000 available in the second half of the year. But the rest of those visas don't really have limits on the number. The key is to find the available candidates and then get the visa for them. So the bottom of this question is, can we go to countries directly to recruit and find people there? And the answer is absolutely yes, you can do that. If you're able to do that and get a pipeline of folks from foreign countries to come to the United States who have the skills to fill your role, that's great. Particularly easy in Canada because we can, in Mexico, because we can take advantage of the TNs. But finding the people is really the hardest part. If you're willing and have the resources available to go do that, that's outstanding. I'll make you this promise: if you go do that, we'll help you get them here. That is easy enough for us to do. And can we interview them in their home country? Absolutely. Virtual interviews, absolutely, we can do that. Frankly, you can take all of these steps in the recruiting with those folks being at home in their country and us being here. The line in the sand that you can't cross is, even though remote work is available and it's very simple for us to work outside of the office, what we can't do without at least some real planning is employ any of those folks who happen to be residing in, I'll just say Canada, I'm making that up. We can't go so far as to employ and pay those folks without accounting for us having employees in Canada and that sort of thing. So don't get too carried away with our ability to work remotely. Our immigration rules contemplate people being physically present here in the United States while they work. They don't necessarily have to be in the office, but they do have to be in the country for the most part. But if you find folks and we can't get them here, there are things we can help you work through for remote relationships with people who aren't actually here in the United States. That is an entirely different conversation and an entirely different presentation.
Yeah, all good points. Well, we've gone past our time frame, but again, the video recording will be available. And our marketing client communications team is going to share that information with everyone. Again, there's a blog that's going to be today, I believe. It's 4 parts, getting in some more details on the H1B program. If you're new to the H1B registration process, today is actually the first day you can go to the website, the government website, and register your company or open up an account. The registration for the individual worker doesn't start till March 1. I'll give a shout out to our paralegals. They're exceptionally good at guiding you through the process or even helping you with the registration process, so you don't have to pay us lawyers to do that. We do have skilled paralegals that can help you with that registration process. And that's a hard deadline. So you can open your account today, begin the registration for your potential workers March 1, and it's a hard stop of noon March 17. Yeah, the plug for us is we're trying to get this information out there so that we can help you with the advanced planning. Look at other options. Is the H1B really the best option? Do we have other options we should be pursuing? So, well, thank you everyone for their time today. We'll address a couple other questions that are more individualized here before we sign off. But yeah, thanks for everyone's time today.
Thank you.
Yeah, thank you.